I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive.
Good evening, ladies and gentlemen, degenerate sleuths of the night. We gather to boldly go where others have refused. Welcome to the DT show, you salty mofos.
A man accused of killing 4 college students is behind bars, and he has ties to northeastern and central Pennsylvania. State police say 28-year-old Bryan Kohberger was arrested this morning in a home in Chestnut Hill Township.
I can't find any case law that would support that idea. That somehow a warrant would be needed for DNA left at a crime scene.
We are expected to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
So, the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
So, get your popcorn ready and your choice of drink. Get your butt on your seat. Like, comment, and subscribe for a treat. Here we go. It's time for the show. The Drunk Turkey Show.
What is up, everybody? I hope you guys are having a fantastic Easter weekend or Resurrection weekend for those that are followers and believers. I hope you guys are safe and are enjoying your family time. And I see a lot of folks putting in the comment section already that they're making desserts or some foods for tomorrow's festivities. And so I wish everybody a happy and safe time. I'm on. I wasn't sure I was going to make it or not. Me and the family have a cabin rented out. And, we got some dogs, so we have to come back at night. I wasn't sure I was going to be able to make it back in time, but here I am. And I'm glad I was able to do so because we got a good show for you guys. Today, we're going to be talking about some documents that were just here recently dropped in the Bryan Kohberger case. And, we're going to talk about what they mean for the case. I think there's some new information that is out there and how we're going to see it come together for this case that is due to start in August of this year. But before we get into it, I want to remind you guys of a couple of things. One, Data Seal, our partnership. If you guys have any concerns with your private information being out there on the interwebs, whether it be your name, address, phone number, religious preference, voting preference, those type of things, check out Data Seal. You get a 5% discount when you use the link in the description. Also, don't forget, we have the official DT House Bill 37 firing squad unit t-shirts available. Links in the description. It's also going to be in the comment section. Also, I know some folks have, they like to follow my little girl's journey, a little Rogie, and she's turning 2, and there's a link in the description for a little party we're going to do for her. And if you guys want to, give her something, we have an Amazon link in the description for you guys as well. So without further ado, let's get into it and let's break it down. Okay, so we're going to start off first with, let's go to the state of Idaho judicial branch website. Here's where they have all the documents that have been released. And we have a total of, 5 documents to go over, and some of them are pretty lengthy, but I've already read them all. I've gone through them, and I've heard some things. And some rumbles in the Discord. And guys, if you guys are interested in being in the Discord, You got to be a member. You hit the member button. Go check out the community post. There's a link. I'll put another link after the show for new members. I put one in yesterday, I believe, so that link should still be good. But go check out the community page, hit the Discord. You can get in as a member on our Discord. But some folks in the Discord were telling me that the Kohbergers were celebrating these documents, that there was, I don't know, maybe something in favor of Bryan Kohberger in these docs. And I read through them. My initial read, I'm not sure what they're celebrating, but we'll break it down. We'll see if there is something to celebrate. Maybe as I go through it a second time, sometimes maybe even a third time on some of these documents, maybe we'll see what it is that their angle that they're going through is. So without further ado, let's break it down. The first one we're going to talk about is going to be, it's going to be order memorializing oral rulings on motions in limine. So before the court on several motions of limine filed both by the defendant and the state, oral argument on motions was held on April 9th, 2025. On several motions, the court rendered oral rulings from the bench. And these are some of these oral rulings. So first, they're going to talk about the inflammatory evidence. So the defendant moves to prevent the state from introducing testimony and evidence that is exceptionally inflammatory, arguing it is irrelevant and unfairly prejudicial. The court finds this motion to be premature. At this point, the defendant has not identified what specific evidence they want to keep out, otherwise defined exceptionally inflammatory. Issuing an order as requested by the defendant would lack any substance. It would simply require the state to abide evidentiary rules and prosecutorial responsibilities when presenting its case. The court finds this unnecessary and therefore denies the motion. So, first one automatically thrown out. I got to say, I really, really like Judge Hippler here. You know, not just in this motion or ruling, but in many of the rulings that he has. You know, he really breaks it down. I like the way he thinks. I like the way he explains himself. He paints a picture that is understandable and easy to follow and read. And I think he's doing a fantastic job. All righty. So the next one, B, is going to be the defendant's motion in limine to use the term murder. And this one is denied. Obviously, the defendant wanted to prohibit the words murder, murderer, and murdered weapon, etc. However, this is a graphic case, and the judge understands that, so he denied this motion here. The next one is the use in terms of psychopath or sociopath. Now, the state does not intend on using any of these terms in trial already. The terms are irrelevant and lack of evidence. The defendant has been diagnosed with a personality disorder or similar mental illness. If, however, the state believes the door has opened to allow the use of such terms, it shall raise the matter in advance outside of the process of the jury or the presence of the jury. I apologize. Motion is granted. And so this is one thing that went in favor of Bryan Kohberger. Also, guys, let me know what you guys are drinking tonight. I'm drinking a Shiner. I haven't had an alcohol or an adult beverage with you guys in a while. And so here we go. I'm going to have one with you. Let me know in the comment section if you guys are having one with me. All righty. So the state had no intention on using any of these terms. And so that motion is granted for what it's worth. Let's see. The next one is improper death penalty comments. Again, this one was denied. The state moved to have the defense not use terms like the state is trying to kill my client, those type of things, which they have used in the past. Basically, what the judge goes in here and says is the court is unwilling to enter an order requiring defense counsel to act professionally and comply with existing rules. And so although they deny the state's motion, in reality, what the state is, or what the court is saying is, we're denying this because it's clear and obvious that she should be acting in accordance of professional behavior in the court. Maybe not. Maybe she hasn't done so this entire time, but with Judge Hippler, I highly speculate that that's going to end up being something that she's going to work on, because I think a lot of the stuff that the defense has gone through just even the stuff that they've won. Like, I'll be honest, the stuff that they've won, like change of venue, the waiver of the of a speedy trial, those things, I think they backfired on Bryan Kohberger. They've allowed the state to present themselves a stronger case, get better evidence against the defendant, and they've also got Judge Hippler. I mean, they had Judge, who was a judge who, in my opinion, was a lot more lenient towards the defense. And, you know, I don't know when this trial would have gone to court had it stayed in Latah County, you know, just being 100% honest with you there. So let's continue this. The next one is the defendant's unnoticed 404B evidence. The defendant moves to eliminate it, to exclude any evidence that has not already been noticed by the state, which at this point is only defendant's pre-homicide traffic stop. So that's what they're referring to. There was a traffic stop on August 21st, 2022 near the Winco involving Bryan Kohberger and allegedly speeding. He was given a citation for not having his seatbelt restraint. Now, this might be another thing I think maybe the Kohbergers are somewhat celebrating, because I'm not sure if in here is where he exactly says it, but when it comes to that traffic stop, the judge is going to allow it, but he's going to redact the part where Bryan Kohberger asks, you know, the officer why it's important to have his phone number. And so, you know, we'll break it down when we get there and what that potentially means. And I do see that as a win for him, because that could have been something that potentially could have been seen negative against Bryan Kohberger, given the fact that that night at that time, he allegedly was surveilling the house for approximately an hour within 100 meters of that house for that hour, just minutes leading up to that traffic stop. And so, you know, a lot of folks, or most folks, can deduce that he may be wanting to not give his phone number out, given the fact that he knew that he had his phone on and he was surveilling for a crime he was going to commit eventually that was going to be pretty heinous and ferocious. And so, you know, you can deduce that maybe perhaps that's one of the reasons why he doesn't want to give his phone number out. Now, I, for one, think they should have kept it in. If he wants to explain why he asked that, you know, officer, why it's important, and explain, you know, at the stand that his intention behind that question, then by all means, he can explain it. Let him testify. But I feel like, I think the state could have won this argument. You know, I think that even when we read it, we'll see that Judge Hippler was kind of like, there's certain places in here where Judge Hippler is making orders, and it's kind of like he's foreseeing some issues and the state's not picking it up. But I'll explain to what I'm talking about here in a minute. So, as an initial matter, the defendant appears to misapprehend the scope of IRE 404. The rule provides that evidence of a crime, wrong, or other act is admissible to prove a person's character in order to show that a particular occasion the person acted in accordance with the character. The defendant takes that position. Other acts encompasses any other acts that any nature other than the crime at issue. The rule is not so broad. Its purpose is to govern the use of character evidence. It forbids the evidence to show a defendant's criminal propensity. And so basically what is going on here is, when it comes to the traffic stop, they want to throw that out because they say that it's another bad act, and that somebody can say, basically, that he committed this crime, so that might lead him to commit this other crime. And that's not the case. You know, a traffic stop doesn't usually lead to somebody committing a quadruple homicide. You know, there's other motivations and stuff that go behind a crime like that. This continues to say that the defendant's Amazon purchases and his graduate paper discussing the proper crime scene investigation techniques do not stand alone, bear on the character, or suggest that he has a propensity to commit crimes, including those charged. Further, the court is unwilling at this point to preclude the state from filing a 404B notice in the future if it determines its evidence is encompassed by the rule. Therefore, this motion is denied. All right. So another loss for Bryan Kohberger. The defendant's motion in limine improper expert testimony, Middleman, to exclude the IGG. Now, this one's interesting. This one's real interesting. So basically on this one is both parties, the defense and the state, want to exclude the IGG. Now, they want to for two different reasons. You know, one, the state wants to exclude it because it's just a tip. They don't want to go into everything that goes along with it. The defense wants to exclude it because it's evidence against Bryan Kohberger. It's evidence that points to Bryan Kohberger, and they don't want it to be used against him. Either way, it's not evidence that is admissible in court. It's like a lie detector test. It can only be used as a tip. Now, this goes on to say that the state has indicated it will present evidence through Detective Brent Payne and the defendant's name was revealed to law enforcement through a tip. To avoid issues at trial, the court advises the parties to arrive at a mutually agreeable narrative about the tip came about. The parties are also directed to jointly craft a jury instruction advising the jurors not to concern themselves with the source or the nature of the tip. I mean, I think that if I was Bryan Kohberger's team, I almost want to say I'd rather have the IGG in, right? Because, you know, the jury is going to say, all right, so somebody tipped off law enforcement about Bryan Kohberger, right? They're not going to come to the narrative or the conclusion that it was through the DNA and that it was a genetic tree. They can't come up to that conclusion. They can't be explained that. And so let's put ourselves in the mind of a juror who doesn't know anything about this case. It leads you to believe that somebody or that Bryan Kohberger may have said something to someone, or somebody saw Bryan Kohberger, or somebody saw Bryan Kohberger with the weapon or something to that nature and notified law enforcement. Right now, it's not like when it comes to this tip that, you know, they're going to bring it up at one point, but they're not going to talk about anything else throughout the entire time. And so it's going to be a long trial. So the jury is going to have to, one, they're not supposed to try to figure out what this tip is about, but, you know, curiosity killed the cat. Human nature is what human nature is. And they're going to wonder what it is. What is this tip? Why is it that, or how is it they got his information, that they went about it? Now, it's already out there that it's his DNA on the knife sheath. Now, the defense is going to argue how his DNA got there, but it's still his DNA, and they're not really arguing that it isn't his DNA on the knife sheath. So, with that being said, I think that if I was the defense, would rather be able to just say it was the IGG than allow the defense or the jury to ponder what the tip could be. You get what I'm saying? I hope that makes sense, because I think, in my opinion, just leaving it up to a potential tip of some nature could lead to a number of potential thoughts there by a jury. You know what I'm saying? There's zero chance they're going to find jurors that don't already know the case. I don't know if that's necessarily true. I mean, it's been a long time. They're not in Latah County anymore. They're now in Ada County, a much bigger place. I'm sure there's going to be a lot of people who are aware of the case, but how many people there's a difference between being aware of the case, and there's also a difference between also being intimate with the details of the case and knowing that there was the IGG and knowing that all this stuff happened. I mean, there's going to be people who know that Bryan Kohberger got arrested, but don't know that he got arrested because of an IGG. Maybe they know that he got arrested because of DNA, but they're not aware of the IGG stuff, or they're not aware of all these videos because they're not, encompassed on YouTube or on the TikToks or whatever the case may be, trying to figure out this case. So yeah, you might find some people who might be aware of the case, but are they aware of the intimate details of the case? Probably not. And it's not like the jurors can talk to each other and go, oh, I know what the tip is. I know they can't do that. So you're going to have some jurors on there who are going to be like, I wonder what this tip could be. And I just think that that's probably not going to be a good look for the defense, but it's a good look for the state. I'm all for it because I strongly suspect that Bryan Kohberger committed this crime. I'm like 100% sure. Like, I'm not a judge. I'm not a jury. I'm not a prosecutor. I'm not a defense attorney. I have a right to my own damn opinion. And my opinion is that this guy did it. And I can back that up with a bunch of facts and evidence that's been presented already, much less what we don't know. I mean, once we figure out what it is that we don't know, that's been, there. Like, for instance, the purchase of the knife, right? The Amazon purchase of the knife and the knife sheath. Before a couple weeks ago, the Kohbergers would have been saying, well, we don't really know that. We really don't know that there was a purchase. Well, now we do know. And that fact hasn't changed, even though you didn't know that. That fact has been relevant this entire time. And so just like I may have known that and some other folks may have known that and it wasn't out there at the time, I know there's a lot more evidence that isn't out there yet that we're not aware of, or that maybe not everybody's aware of, or majority are not aware of, that when we find out is going to prove this case even more. All right, so let's continue this. The next one is the defendant's conditions as an aggravator. Defendant moves to prevent the state from using the defendant's. So this is one of the ones I was talking about where it seems like Judge Hippler kind of takes a step in, right? So this one says, as I was reading, it says the defendant moves to prevent the state from using the defendant's diagnosis of autism spectrum disorder and the characteristics of his ASD as an aggravating factor at the penalty phase of trial. The state responds it has no plans of such evidence as an aggravating factor in light of Zant versus Stevens, but it will argue against a rebut of the defendant's diagnosis to the extent he relies on it as a mitigating factor. Despite the state's concession, the court is concerned with the breadth of the defendant's motion. He is not only seeking to preclude the state from referencing his ASD diagnosis as an aggravator, but any symptom of his ASD. Given the broad nature of ASD symptoms, the court foresees an issue potentially arising at trial whereby the state makes a reference to an action taken by the defendant that the defendant contends is a symptom of his ASD. Now, we're going to read that here in a little bit later, that I think it's under the neurological one, where they talk about him wearing gloves, washing his hands over and over again, being out late night drives, et cetera, et cetera. And the reason why this is important is because if the state goes up there and they try to use this as proof, right, that one, he was trying to prevent contamination, that's why he's wearing the gloves. Well, Ante's going to say, objection. No, that was from part of his ASD. You can't use that against him. And now it's a problem because they're claiming it's part of him being autistic and the state's claiming, no, that is him trying to prevent his DNA being left behind. The constant washing of his hands is probably a paranoia because he committed this crime and he was afraid he may have had DNA or something from the victims onto him. Those type of things. The constant late at night drives, etc. That's probably because he was driving around before the murders. I don't know what his driving pattern was after the murders, but before, obviously, he was out and about up to 23 times within 100 meters of that house, leading up to the week prior to the murders. So up until November 7th, he was there 23 times within 100 meters. So, just kind of food for thought there. Let's see. So the judge sees that as a potential issue, right? That they're going to be, the defense is going to be able to object to almost anything and say, no, that's a symptom of his ASD. And so I'm glad that they stepped in because the state only said, well, we have no intentions of bringing up his autism or saying any of these characteristics and using that against him. But I don't think they understand is that what they intend on using against him, the defense can potentially, I'm not saying that they are because they haven't done it yet, but there's room here. And I think Judge Hippler is seeing there that the defense can use some of those behaviors that they plan on using to show intent or show knowledge of, or whatever the case may be, as a symptom of ASD, so that they can bring it into court. And so he goes on to say the evidence is not currently before the court. Thus, at this point, the court will preclude the state from arguing or presenting evidence of the defendant's ASD diagnosis as an aggravator, but it is not in a position to rule on whether any particular evidence must be excluded on grounds of that evidence a symptom of the defendant's ASD. The motion, therefore, is granted in part only. And I love the fact that he did that, because had he just kind of said, all right, state, we'll just take your, you're not going to bring it up in that manner, they concede to it. So sign, seal, deliver, you got your motion granted. Love that they did that in this situation. I love that Hippler did that here. All righty. So the next one is the state's motion in limine for alternative perpetrator evidence. The state seeks an order prohibiting the defendant from offering alternative perpetrator evidence without first making showing that such evidence is relevant and admissible under IRE 401. These rules govern the standard of admissibility for alternative perpetrator evidence. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to limitation provisions of IRE 403. All right. According to the defendant, this case is full of alternative perpetrators. According to the defendant, Cyree was going to say a bunch of stuff too, right? And that didn't work out for him. But let's continue. He intends to produce and offer proof as of alternative perpetrators. While the defendant is correct that such offers of proof can be made at trial, this case is well suited to waiting. This case is not well suited to waiting until the time of trial to do so, particularly if the defendant intends to submit multiple offers of proof. Laying foundation for admission of evidence will likely take a significant amount of time. After all, the defendant cannot merely show another person could have committed the crime. Rather, there must be evidence linking the third person to the actual perpetration of the crime. So I think there's something to be said in here. And I think that it kind of can show where the defense is going to try to say maybe perhaps one of these alternative perpetrators are. And I think we've known about who this perpetrator was, because they say that the defendant cannot merely show another person could have committed the crime. So who could have committed the crime? Who was in the area? Who was with the victims? Who lives fairly close? Who was being called? And obviously that's one of these persons is going to be Jack DeCore. Now, he was in the area. He was, but his DNA isn't what was left on the sheath right now. I don't know what kind of, we do know what kind of surveillance was in the area. We have the 1122 King Road surveillance camera. And what it captures is a white vehicle pulling in. Now, what it's probably capturing earlier on is Jack DeCore's vehicle pulling in. And so if it were to be Jack DeCore, he would have had to have gotten that white vehicle where? Right? And how would he have gotten there? How would he have gotten to the 700 block of Indian Hills Drive and magically show up in a white Elantra without a front license plate? Right? Now, I guess maybe, the pro-burgers might argue, well, maybe there's nothing to the white Elantra. It's just driving in the area. Well, I mean, that's a stretch because it's driving in the area. And then the time that it specifically stops in the area is the time that the murders are happening, and there's audio video that you can hear, the thud and everything else. Plus you have phone calls from victims inside the house, Dylan and Bethany. So during the specific time of the murder, the white car is not moving. And then shortly after it's leaving the scene at a high rate of speed. And so it's a huge stretch, right? So I think that could be one person. I don't know if the Sigma Chi thing, I don't think it's real. I've never heard anything concrete from anybody that actually knows people there, that knows people in Moscow. Like nothing. Like I've not been able to verify that any of those things actually happened. I know that some people will cling on to, I think, I think it was Xana's mom, Kara, who had mentioned something about potentially knowing that something happened at the Sigma Chi thing. But I don't know. I mean, there was a lot of things that she wasn't very accurate on, to be honest with you. So I just don't know. But outside of her bringing it up at one point, like nobody has broken that silence. Like nobody, none of the Sigma Chi guys, none of their girlfriends. If they've broken up with somebody, right? None of their ex-girlfriends, none of these people who may have been there who don't like them, because you can't tell me that everybody love these people, right? I mean, everybody has somebody that don't like them, and nobody's bringing up any type of information that about this. It's just kind of hard to believe, especially when you know all the evidence that we know so far. Not everything that they have, but so far. All right, let's continue. All righty. So this also goes on to say that the defendant cannot merely show another person could have committed the crimes. Rather, there must be evidence linking the third person to the actual preparation of the crime. Oh, they even use the oh man, I'm struggling with that word. It must be the beer. To avoid undue delay at trial, the defendant must present the offers of proof no later than May 14th, 2025. So this matter can be addressed at pretrial conference. The court will reserve ruling on this motion. So that'll be a good hearing. I'll be interested into hearing how that one comes out. May 14th, not too long from now. Yeah, less than a month. All right. So the next one is the statistical the defendant's motion in limine for statistical analysis. The defendant moves in limine to exclude any misleading comments about the meaning of likelihood ratio for DNA purposes. The state agrees to this type of comparison is inappropriate, and the court grants the defendant's motion. Thus far, this has to do with the DNA underneath the fingernails of Madison Mogen. The state has stated that they believe that DNA did not belong to Bryan Kohberger. And they believe that because of what he was wearing, and they've been able to piece together basically his entire kill kit, they don't believe that, and also the intoxication levels of the victims, they don't believe that that his DNA would have been left behind. And it's interesting, and I think that they bring up that May 2020 investigator final report where he goes into detail about how an investigation should be done. And he talks about the materials that he would wear, so that way he doesn't contaminate a crime scene. Interested if those materials are prevalent in his kill kit. All right, we'll move on. The next one is the inconclusive data, and this is also referencing the DNA there as well, the likely ratio. The states here, the defendant moves to limit the expert testimony about the swab taken from the fingernail clippings of Madison Mogen. The test revealed likelihood ratio in the inconclusive range. And so that's basically everything I was talking about right now. All right. And so the next one, and the judge does say that if things were to change, because he denies this as a moot order, but he does say that if things were to change, and let's just say the state were to decide to say that the DNA it's inconclusive, which means it still could be his, then they can raise the question there. But since they don't have any intention on doing so, then that's why it's not going to happen. All right, let's move on. The next one is excluding Amazon click activity evidence at trial. Defendant moves to exclude any evidence of the defendant's Amazon purchase history or click activity on the grounds that it is out of context. This evidence will be presented by the state through Shane Cox and Michael Douglas, who will testify simply that the documentary evidence state, all of which was provided to the defendant in discovery. Basically, what it says is these guys aren't experts that are going to come in and talk about how what you look at is going to be what they showcase, like ads or etc. Like Google Pixels, I think is what it's called. Also, where what a person is looking at their screen, they'll show them ads based on those type of things, and all they're going to do is talk about what was purchased, what wasn't purchased, what was clicked through, what wasn't clicked through. The court goes on to say the evidence is highly irrelevant. A K-bar knife sheath was found lying next to the body of one of the deceased victims, all of whom were stabbed to death. The defendant's DNA was found on the knife sheath. Records from Amazon account registered to the defendant's name and email show the purchase of a K-bar knife and sheath was made from an account approximately 8 months prior to the homicide. Click activity on the same account shows the customer also viewed pages associated with K-bar style knives at that time and in the following week and in the week following the purchase. So he was still looking at knives. Interesting. I wonder if he did have two knives, because he was looking at knives the following week after the purchase. View pages associated with the shipping progress of the knife and sheath. Interesting. The product was shipped to Bryan Kohberger, his family address in Pennsylvania. Oh my God. If you think he's innocent, how slow do you got to be on this one? He shipped it to himself, Bryan Kohberger, to his address. Man, this guy's stupid. After the homicides, activity from the same account showed that the user navigated pages related to the deletion of the account activity, and a week later viewed pages associated with a K-bar knife and sheath. The evidence establishes a significant connection between the defendant and the K-bar knife and sheath. Damn, a significant connection. Let's see. After the homicides, from the same account showed the user navigated pages. The pages is a week later. So a week, 7 days after the homicides, he's looking for another K-bar knife and sheath. That's crazy. That's what that mother trucker was doing on Thanksgiving. He was looking for another knife and another sheath. In addition, there is no bias under IRE 403 to exclude this evidence, particularly given how probative it is. The defendant is free to challenge the evidence through cross-examination and examine and establish Mr. Howell why more information is needed to reach the conclusion the defendant purchased or clicks. However, it is not bias for exclusion. There is nothing inherently unfairly prejudicial or misleading about the evidence itself. It will be up to the jury to consider all the evidence and decide whether the defendant was the clicker. Thus, the motion is denied. I mean, this is the biggest one, right? I mean, they've connected him now to the knife and the knife sheath. The vehicle matches the vehicle like his. You got a defendant or a witness that has seen somebody that cannot exclude him. They have basically put together his entire kill kit. I mean, how many more dots do you need to connect this line that points directly to Bryan Kohberger? I mean, it's just, he can't figure this out still. It's sad. That's just the truth. The state motion eliminating AT&T timing advance records. Oh, this one's a good one. The state moves. Oh man, good old Cy Ray, dude. He gets it again. I mean, he's still walking funny from the last time he got it, and he gets it again from Judge Hippler. The state moves in the state moves in limiting to prohibit the defense from making any reference to the absence of AT&T timing advance records related to the defendant's cell phone. The state contends it never received such records from AT&T in its response from the subpoenas, and therefore any statement by the defendant that the records could have or should have been provided to the defendant should not be allowed as it mischaracterizes the evidence, will mislead the jury, waste time, and cause undue delay. The state provides certificates of authenticity, AT&T, for which one of the two warrants stating it did not provide AT&T timing records for the phone number belonging to Bryan Kohberger, because such records were at that time only available if requested within 7 days of a specific time frame. The defendant, relying largely on affidavits of its expert, Cy Ray, is adamant that the state did receive documents, which he argues are exculpatory, and is hiding them. Oh my gosh, man. The defendant points out that he has a constitutional right to challenge the evidence against him, therefore must be allowed to explore the state's misrepresentation as to its availability of the records. The 6th and 14th Amendment guarantee the criminal defendant a meaningful opportunity to present a complete defense. This includes the right to confront and effectively cross-examine witness. However, these rights are not absolute. The trial court may reasonably limit cross-examination that is harassing, confusing, repetitive, or marginally relevant. The confirmation clause guarantees an opportunity for an effective cross-examination, not cross-examination. That is effective in whatever way and to whatever extent the defense might wish. Additionally, a defendant has no right to present irrelevant evidence, as even if evidence is relevant, it may be excluded in certain cases. Applying these principles here, the defendant will be allowed to voir dire Special Agent Balance outside of the presence of the jury to ask whether he received the defendant's TA records covering the early morning hours, November 13, 2022, and this month prior, when the defendant was believed to have been in the area of 1122 King Road. However, if Agent Balance denies having received the TA records, the defendant may not explore the matter further, either in voir dire or before a jury, given absolute lack of factual basis in supporting his position that the state is hiding them. Unless the state's motion is granted, except as qualified regarding to the brief voir dire outside of the presence of the jury. Now, there's some stuff here I wanted to read. So some footnotes. Number 9, the homicides occurred November 13th, 2022. The defendant became a person of interest on December 19th, 2022. The 2 AT&T warrants were issued on December 23rd. Thus, AT&T, the timing advance records for the defendant could not have been any relevance and had long been discarded by AT&T, no longer existed. This is the best one, though. Number 10. Mr. Ray's affidavit, which forms the basis of the defendant's challenge, is replete with speculation and unfounded, and thus highly improper accusations against the state. Further, not once in his affidavit does he address the AT&T 7-day retention period, which fully explains why the state was unable to obtain relevant TA records for the defendant. So he basically said that his entire thing is full of speculation and is unfounded. He called it a conspiracy theory. Cy Ray's work has been called junk science in other courts and has been thrown out. I mean, I think this guy's career is over when it comes to this line of work. You know, is what it is. Man, I could use another beer. Hit. All right, next one. Admissibility of demonstrative evidence. The state seeks permission to use a not-to-scale 3D model of the 1122 King Road residence as a demonstrative exhibit at trial. This is going to be the dollhouse is what the defense calls it. And this is only going to be something to aid the witnesses so that they can point out certain things. The defense, doesn't want this to be allowed, even though they can use it too. But their claim is that because it's not going to be to scale. I think, this is my conspiracy hat, putting it on or whatever. Bryan Kohberger mentioned that he would have a model to scale, right? In his 2020 report. He's OCD supposedly, right? So is it possible that maybe perhaps they're doing this not necessarily as a demonstrative thing, but I mean, maybe that's his main purpose, but a little side purpose of just to kind of dig at him a little bit, knowing that might bother him. I mean, the defense is really concerned about his behavior. They're afraid of what the jury might see because he's a crazy person, apparently. I mean, he did commit allegedly a quadruple homicide, so I'm sure he is a crazy person. Let's see. Oh, thank you. Defendant contends that the model, let's see. Yeah, now I already went through all that. We don't need to go through. The motion is granted. They're allowing the dollhouse. So the next one is, let me make sure it wasn't anything green. Green is important. State's motion to eliminate the alibi. Now, this is one I think that the pro-burgers were celebrating this ruling. But I mean, I'll be honest with you, I'm not against this ruling. But let's break it down. So the state's motion of alibi, the state moves to preclude the defendant from offering any evidence in support of an alibi other than himself. The basis for the state's motion is the defendant's failure to comply with the notice of requirements governing alibi evidence. If requested by the state during discovery, a defendant intending to offer an alibi must file a notice listing the specific places or place at which the defendant claims to have been at the time of the alleged offense and the name of the addresses and the witnesses upon in which he intends to rely to establish such alibi. The court has the discretion to exclude testimony of any undisclosed witness offered by the defendants, offered as to a defendant's absence from the scene of the offense. An alibi is a defense based on physical impossibility of the defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant time. So right now, Bryan Kohberger's partial alibi is that his phone didn't turn off at 2:47. It turned off at 2:54. I mean, the crimes happened at 4:07, like over an hour later and less than 20 miles away. So what are we talking about here? Hence, in setting forth the notice requirements for an alibi defense, I require a defendant to proffer evidence establishing where the defendant was at the time of the alleged offense. Evidence only counts as an alibi evidence if it proves the defendant could not have been present at the scene at the offense at the time it was committed. Again, if you can prove he wasn't at the scene at the time the offense was committed, not something that happened an hour and like 7 minutes, 12 minutes, 15 minutes earlier. If an alibi fails to account for a defendant's whereabouts for at least some period of the time during the crime was reasonably committed, it is not an alibi. It's not an alibi. At this point, the defendant has only provided notice that he was out driving around in the early morning hours, November 13th, 2022, throughout the area of South Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert, Cy Ray, to partially corroborate his alibi using CSLI data from the defendant's cell phone. However, the alleged offense occurred between approximately 4:07 a.m. and 4:20 a.m. At most, Cy Ray can opine as to where the defendant's cell phone was up until 2:54 a.m. when it was apparently turned off. At approximately 4:48 a.m. when it began reporting back to the network. The defendant has provided no evidence of his location at the time of this crime. In other words, he has provided no alibi evidence as contemplated by the rules. So at this point, the state has, or the court has, acknowledged that Bryan Kohberger has no alibi. He has no alibi. And so that said, and this is what goes on, the court will not categorically preclude the defendant at this point from offering alibi evidence at trial. Whether to exclude late disclosed alibi evidence requires weighing prejudice to the state against the defendant's right to a fair trial and considering whether less severe remedies are sufficient. There are still 4 months until the trial begins. If the defendant doesn't unearth alibi evidence, it is his obligation to immediately make it to the state and the court aware of it. At that point, the court can apply Juarez standard. Excluding it at this time is premature, and therefore the motion is denied, subject to being re-raised if the defendant does disclose alibi evidence. However, at this point, the defendant has not provided an alibi, partial or otherwise. So they don't even consider the 254 thing a partial alibi. It's not an alibi. At this point, it's not an alibi, and he's not considering what Cy Ray is saying as a partial alibi. So guess what? He's not going to allow that into court. Now, they're going to have to find somebody that says he was somewhere else or something that proves it. Now, I'm not against this. If Bryan Kohberger truly did not commit this crime and there's something out there, like some camera that shows his license plate somewhere else, because at this point, there's a significant, robust, strong case against him that he was at the 1122 King Road residence. And so if they just saw, for instance, a white car on a camera somewhere else, at some other point, that's not enough, right? Not enough compared to what they have against him. Now, will they allow him to use that? I don't know. I mean, I don't think so because of how close it is. Now, if it was something that showed his plates, or if he had another phone and it was on and showed him somewhere else, that can be used. That can be used in his favor. But that's where the line is, right? At this point, because he's not provided an alibi. Partial or otherwise. So at the end of the day, if he brings something in, he still has to prove it. Good luck. I mean, if it's like kind of the same format that other things have been going, I doubt it's going to go anywhere. The next is the state's 404 notice prior traffic stop. The state moves under IRE 404, admission of the defendant's August 21st, 2022 traffic stop in Moscow, Idaho, during which he was stopped for speeding and issued a citation for failing to wear a seatbelt. All right. And so specifically, the state seeks to admit the officer's OBV footage. I believe that's his onboard vehicle footage of his traffic stop, as well as a citation, arguing it is relevant to providing the defendant's identity, vehicle ownership and control, access, and phone number. The defendant's object pointing to the Idaho Supreme Court case law. You know what? Let's go forward a little bit. Blah, blah, blah. So here's where it gets good. Confusingly, the defendant argues his prior traffic stop bears no resemblance to the charged crimes and therefore cannot be relevant to his identity. He also argues it is unfairly prejudicial and may confuse issues. But the court is confused by the defendant's argument. Evidence of other crimes, wrongs, and acts may be admitted pursuant to IRE 404B when it is probative of value and is entirely dependent upon its tendency to demonstrate the defendant's propensity to engage in such behavior. Such evidence may, however, be admissible for other purposes, including to prove identity. To determine the admissibility of the evidence under Rule 404B, the court must find the evidence is sufficient, established as fact, and relevant as a matter of law to material and dispute issues other than character or criminal propensity. The court finds the evidence is relevant to establish the defendant's identity and link him to the charged crimes. Indeed, the citation and OBV footage up to the point that the defendant provides his phone number serve to identify the defendant by name, physical appearance, phone number, and address. The evidence also establishes the defendant as a registered owner and driver of a vehicle, the make and model of which was thought to be used by the killer. For instance, the evidence places the defendant in Moscow at night on one of the dates of interest alleged by the state to be relevant to planning the charged crime. All the factors played a role in the investigation of the crime. While the defendant cites to case law discussing identity under IRE 404B as requiring strong similarities between bad act to the charged crime, this is in context of establishing identity through signature quality or modus operandi. The state, however, is not seeking to introduce the prior traffic stop to establish modus operandi. Therefore, the defendant's case law and argument is not well placed. Upon weighing the IRE 403 factors, the only portion of the OBV footage the court finds troubling is when the defendant inquires why the officer needs his phone number. The inquiry could be perceived by jurors as insolent, and given its lack of relevance and potential for prejudice, the inquiry shall be redacted, which is a victory for the Bryan Kohberger crew. I was hoping that this wouldn't be redacted. I felt that it could have been argued that he doesn't want to give his phone number because he was just surveilling a house that he intends on committing a violent crime at. Other than this redaction, there is no basis for a further exclusion. The defendant's claims of unfair prejudice and jury confusion lack merit. First, he argues there is no nexus between the traffic stop and the charged crimes. Thus, the jury may consider the propensity of evidence otherwise to be confused. All right. A traffic stop, particularly one of this as minor as this, is not the type of evidence that will compel a jury to conclude the defendant is guilty of murder because he violated traffic laws. Further, the court will provide limiting instruction. The defendant also contends it is unfairly prejudicial because the OBV footage provides a clear shot of the defendant's vehicle, which may lead the jury to believe it's a suspect vehicle captured in the surveillance video at and near the crime scene on November 13th. However, this is precisely what makes the evidence probative. It links the defendant to the crime scene. While this may be damaging to his defense, it is not unfairly prejudicial. Exactly. When balanced against its strong relevance. Thus, the motion is granted with the noted redactions. So they're going to allow the tape in. All right, so that's the first one. Whew. It went a little bit longer than I thought, or I'd hoped. About an hour into that one. I was hoping only to be here an hour. So we're going to do a little bit of OT. Okay, so let's leave this one. The next one is the order on the defendant's motion to eliminate make, model of the suspect vehicle. And this motion was denied. But let's read some of this. So it says in the early morning hours, November 13th, surveillance videos from various locations near the crime scene picked up footage from law enforcement believed to be the same vehicle as suspect vehicle 1. So basically the entire argument is that there isn't a continuous footage of suspect vehicle 1. And on one specific cameras where they were able to specify that the vehicle was between a 14 and 16 Elantra. And so the defense is trying to say they shouldn't be able to call all of these vehicles suspect vehicle 1 because you can't tell if they're all suspect vehicle 1, even though they're all very close to each other. And granted, there might be a short break. That vehicle pops up when it's supposed to be as anticipated. And so in the end, it states here, the state response to the testimony is based on logical, educated inferences drawn by law enforcement from surveillance videos. It adds that testimony does not invade the province of the jury and is highly relevant to determine whether the vehicle captured at 404 on the King Road camera was the defendant's vehicle. And, they go on to say that they shouldn't be able to say a bunch of different things based on the fact that these law enforcement officers weren't, I guess, experts. I don't know. They lost. Based on their finding, they lost it. The jury is free to weigh the evidence and the investigators. I mean, at the end of the day, did anybody really think that one was going to win? Like, it is literally a third of a mile away. The 1120 or the 1125 Ridge Road camera and the Linda Lane camera that captures the vehicle passing in front of it, the 1321. And then you have the 1112 King Road that you see the vehicle turn on just like another half a minute later. So you can see it. It's all within a third mile. The victim's house from 1125 Ridge Road to 1122 King Road is a third of a mile. And in between that, there's three cameras that capture, maybe 4 cameras that capture Bryan Kohberger's vehicle. And it's in that specific order at that odd hour of night. Like the likelihood of somebody intersecting in between there it's crazy. It is crazy. Hold on. I got to pull up one more thing. Okay. All right. And so let's close this one. They're going to get to use the car. All right. The next one is the touch and contact DNA. Now, this one's a good one, too. I like this one. So the defendant moves in limine to exclude the testimony of Rylan Nolan, the lab manager with the Idaho State Police Forensic Laboratory, who was disclosed to the state testify about touch DNA and transfer DNA generally, and more specifically that the DNA located on the knife sheath was more likely the result of direct transfer. The defendant argues that Ms. Nolan's testimony was, as well as other testimony referencing the terms touch and or contact DNA or purporting to be an opinion about the means of the mechanism as to how the DNA ended up in the knife. Basically, what they're saying is, in layman's terms, is that by saying touch or contact DNA, that implies that Bryan Kohberger touched or contacted that knife sheath. And when it comes to touch DNA or contact DNA, you can't. Let me see. They worded pretty interesting that you can't basically determine if he actually touched it, because one person can touch something. Like I can touch my computer. Somebody can come in here, touch my computer. Now they got my DNA on them and they can go other places. But the thing is, this was single source DNA. Now they want the defense, that is touch or contact DNA or touch or contact, to be thrown out. They don't want those terms to be used. I think this is another reason that they ended up winning, that they're probably going to regret, in my opinion. But let's look at the facts of the case. A knife sheath was recovered from the crime scene in this matter and swabbed for DNA. A sample of DNA identified as Q1.1 was extracted from a swab by the Idaho State Police Forensic Lab. The DNA concentration was 0.168 mg/UL. It was subsequently tested in using standard DNA STR. The methods the STR profile developed revealed that the DNA came from a single source male profile. I remember the Kohbergers were really big on the fact that this was a small amount of DNA. Now, I knew, based on the fact that it was 1 in like 8 octillion to 1 chance that it was somebody else, that it wasn't a small amount of DNA. But I wanted to make sure. And so I did a little Google search. Right? Let's look at that. A concentration of 0.168 mg/UL DNA is equivalent to 168 UL micrograms per microliter, or 168,000 nanograms per microliter. This is a high concentration, and depending on the intent used, it may be too high for some applications like PCR, or optimal range between 25 and 100. So this is a lot of DNA. This isn't a small one. This isn't a small amount of DNA. This is a large amount of DNA. What you need is between 25 and 100, and oh boy left 168. So there you go, guys. I mean, take that for what it is. It's a high amount of DNA. It's a large amount of DNA. It's not a small amount. All right. So the state disclosed Rylan Nolan, the lab manager for the ISP lab, to testify to the operations of the forensic laboratory and the structure of the ISP lab testify evidence process. Their disclosure states that Ms. Nolan will testify to touch DNA and transfer DNA. Specifically, Nolan will testify to the characteristics and nature of touch DNA, including how it was deposited or transferred from an item of evidence, methods used to collect and preserve touch DNA. All right. And so it says here on February 17, 2025, the state submitted its rebuttal disclosures, including one of Ms. Nolan. The focus on the second disclosure is touch contact DNA and direct versus indirect transfer, including factors that can influence the transfer and persistence of DNA on an item. And the final paragraph of a rebuttal disclosure states many complicated factors can influence the likelihood transfer of DNA and the persistence of the transferred DNA after deposition. Current DNA technology cannot conclusively answer the question of whether the DNA was deposited on an item by what mechanism, direct or indirect. It is possible the DNA detected on M2022-4843 item 1.1 resulted from secondary transfer. However, based on Nolan's training and experience, in her opinion, given the quantity of the DNA detected, so the high amount of DNA, and given the DNA obtained as single source, is most likely a result of direct transfer. So like I said, it is a, when it comes to touch DNA, a lot of people ask, it can get, you can touch this and touch that and this person can touch that, or could rub against this. But the most common way somebody gets touch DNA on an item is by touching it, especially if it's single source. Especially if it was single source. All righty. And so the defendant's argument is threefold. First, he seeks to exclude any testimony by Ms. Nolan regarding when or how the DNA found on the sheath was transferred. They're arguing it conflicts with current consensus with forensic science community. It is outside of her expertise and is speculative. Second, he argues generally that it is that use of the terms touch and contact DNA should be prohibited at trial is misleading, confusing, and unfairly prejudicial. Finally, he argues that Ms. Nolan rebuttal opinions must be stricken as improper rebuttal. So let's go through it. When it comes to her being an expert, right here, number one, Ms. Nolan is sufficiently qualified. Goes into how she's an expert and on her opinions. With regard to expert testimony regarding the transfer DNA, the report explains, with the except of the ground truth known experiments where an individual is observed to have been in contact with a surface location, it's not possible to know whether the transfer was direct or indirect. Further states that providing opinions about the probability or possibility of direct or indirect transfer is problematic, stating evaluations considering factors such as transfer, persistent, and background require an evaluation of biological results given propositions that address not the source of the DNA, but the activities that may have taken place. So this is where they go in and they talk about something called DNA TPPR, and they try to basically say that Ms. Nolan is not an expert, that she's not an expert in this. And the court goes on to say, based on the two articles, the defendant posits that Ms. Nolan, as a typical lab analysis, is not qualified to substitute her judgment in the face of the weight of the forensic community's agreement that the science and literature does not support an analysis testifying of when and how to transfer. The state's response to the defendant's argument is both legally and factually flawed. The legal flaw is that it misapprehends the appropriate standard to determine admissibility of an expert opinion. The state asserts that the standard is not consensus with the scientific community, but on whether her knowledge will assist in the tier or fact. The factual flaw is the defendant's failure. The factual flaw is the defendant's failure to mention the lack of consensus with the EWG report regarding recommendation 7.1 footnote. And they basically go on to say that the court finds Ms. Nolan to be sufficiently qualified to render her opinion on DNA transfer despite her lack of specialization in the DNA TPPR. According to her affidavit, Ms. Nolan currently qualified and proficiently tested as a DNA analysis and has been qualified for 20 years. Long time. Goes on to talk quite a bit about her background there. She's definitely an expert. Based on her professional experiences in forensic DNA field, Ms. Nolan, at the very least, possesses the general expertise to opine the matters of the DNA transfer. The defendant is seeking to hold Ms. Nolan to an aspirational standard of expertise in the forensic field that is, for now, is nothing more than a recommendation, and a disputed one at that, within a segment of the forensic science community. Not only do the defendant's articles fail to establish any established standard of qualification, Ms. Nolan disputes that there is consensus in forensic DNA community that the DNA analysis should not opine as DNA TPPR. In sum, given the liberal standard for qualifying as a witness, Ms. Nolan experiences and training in the area of forensic analysis of the DNA, generally the current divide in the forensic community regarding whether lab analysis are qualified to testify to DNA transfer, and the lack of jurisprudence on the matter, the court declines to find that Ms. Nolan lacks the qualifications necessary to provide an opinion on the DNA transfer. In this case, the defendant challenges her qualifications effect simply to weigh them to afford her testimony. All righty. Ms. Nolan testimony will assist tier of fact. Having determined Ms. Nolan is qualified and expert, the court must determine whether her testimony will assist in the tier of fact. Understanding the evidence in this condition goes primarily to relevance. Defendant argues that Ms. Nolan's rebuttal opinion that the DNA detected on Q1.1 is merely likely the result of direct transfer is speculative because the possibilities that are based on substantive scientific principles. The state responds that Ms. Nolan's rebuttal disclosure sufficiently explains the scientific principles underpinning her opinion to the reasons for her opinion. In addition to the fact that Ms. Nolan cannot testify conclusively as to how and when the DNA arrived on the knife sheath does not, according to the state, render her opinion speculative, otherwise unhelpful to the jury. The court finds Ms. Nolan has identified an adequate scientific basis for her opinion. Her rebuttal disclosure reveals she will discuss the difference between single-source DNA, profiles and mixtures, concepts pertaining to direct and secondary transfers of DNA, and the variables that can influence the transfer, persistence, and recovery of DNA. In addition, although Ms. Nolan admitted cannot testify conclusively as to whether the DNA was transferred to the sheath by direct contact rather than indirect contact, this does not render her opinion speculative. Testimony is speculative when it theorizes about the matter to which evidence is not sufficient for certain knowledge. Ms. Nolan's opinion does more than suggest possibility. She states that while it's possible the DNA on the knife sheath was from a secondary transfer, it's more likely the result of direct transfer given that the DNA was single source and there was a 0.168 ng of DNA detected on the sheath. As the state points out, an expert may testify to the likely opinion, particularly where the expert acknowledges the limitations of such opinion. Ms. Nolan's opinion is no different. She will testify that based on the scientific principles regarding DNA transfer and her observations, the quantity of DNA, and the type of profile found on the knife sheath, it is more likely the direct transfer rather than secondary transfer. I mean, this is just boom after boom after boom, where that this is all going to end up coming out. And given the high quantity of it, it's pretty crazy to think that it doesn't belong or that it wouldn't be directly transferred. Now, the court brings up a specific incident here. It says here, neither party has cited the case law discussing the admissibility of expert opinions on DNA transfer. However, the cases reviewed by the court indicate that Ms. Nolan's opinion is acceptable despite her inability to reach a definitive conclusion. The government's DNA expert, so in the United States versus Perez, the government's DNA expert testified about DNA transfer with regard to a mixed DNA profile found on a gun, 85% of which was attributed to the defendant. He discussed the differences between direct and secondary transfer and the variables that can affect DNA transfer. And he further testified that the amount of DNA found on the secondary transfer, found from a secondary transfer when compared to a direct transfer, is expectingly less, specifically stating, I haven't seen an example their primary toucher has less DNA than the secondary person. And typically the initial touching is going to have more DNA to testify to the possible, but general, you would not think that direct touching is going to transfer more than that individual's DNA. Based on the testimony that the fact that 85% of DNA was attributed to the defendant, the court concluded that the jury could reasonably infer the defendant's DNA was deposited by direct transfer. That was a mixed DNA sample, and 85% belonged to that defendant in that case. In this case, it's 100% Bryan Kohberger's. 100% Bryan Kohberger's. Come on now. All right, let's see. So we already talked about that. And the other thing that I had read here is that there was a specific place where it said that where the judge was talking about the motions from the defense and that they had failed to cite some of their stuff, but he went in there and found it and that they were wrong. I hope I didn't pass over it. I think may have been in a footnote. It may come up here pretty soon, but it's just crazy. So the next part is going to be about saying trace or touch DNA or whatnot. And so, long story short, and the efforts to save time here, there has been times where even the defendant's witness has said touch DNA, and they bring it up in this specific place, but they're going to try to exclude that so that way they don't say that it was touch DNA. But I think that's a problem because, you know, if you're a juror and you're sitting there and they say, all right, well, we got Bryan Kohberger's DNA on the knife sheath. Well, you're going to wonder what kind of DNA it is, right? Now, if they tell you it's touch DNA or transfer DNA, that might be something that could tell you, all right, well, it could have been there a number of ways. But they're not going to say that. They're just going to say it's DNA. which opens a realm of possibilities. It could be blood, it could be hair, it could be spit, it could be skin cells, it could be a lot of things, you know? And so I think this is another ruling that they won that's probably going to not benefit them in the end. Let's see. Rebuttal evidence is the evidence that explains, repels. Okay. As the state notes, the defense DNA expert Ruth Ballot acknowledges there's a good support that Mr. Kohberger's DNA was found on the item. See, they're not even arguing. The defense isn't even arguing that it's Bryan Kohberger's DNA there. However, the report indicates that she will inform the jury that DNA on an item could be a result of indirect transfer. So she's going to say that it could have been there from multiple ways, but they're not disagreeing that it's his DNA. And you can't, once you figure out how much DNA that it is, it's obviously his. Obviously his. So based on the foregoing motion, Rylan Nolan reference to touch and contact DNA is granted in part and in denied in part. Let's go to the next one. Order the defendant's motion, witness identification of bushy eyebrows. So this one's going to have a lot of Dylan's statements. So this says here, Dylan is a roommate of the victims in the case and was the sole witness of the intruder and believed to have carried out the homicides at the 1122 King Road residence. During her interviews with law enforcement, DM described the intruder of having bushy eyebrows. Defendant moves in motion limited to exclude any evidence at trial referencing this, arguing DM's description is unreliable, therefore irrelevant. All right. So some facts here. November 13th, sometime before 419. So remember, there's a screenshot of Bryan Kohberger leaving at a high rate of speed at about 420 in like 45 seconds or so. Sometime before 419. So at least at 418, 417, Dylan sees somebody walk out. So he was out there for more than just a couple of seconds at his car. You know, he was out there for a few minutes, probably getting, doing some DNA mitigation, changing stuff like that. So let's see. DM placed several phone calls and sent several text messages to her roommates. The only roommate who responded was Bethany, who resided downstairs. They had 2 short phone conversations and exchanged text messages. Within those phone calls and text messages, DM relayed to BF that she saw a person in the residence wearing black and had a ski mask that covered his forehead and mouth. The same day at approximately 11:56 a.m., a 911 call was placed from the 1122 King Road residence for a reported unresponsive female. Officer Mitch Nunez took a statement from DM. She told Officer Nunez she saw a male not insanely tall wearing all black and a mask that was just covering his forehead and mouth. DM later repeated the description. He was a little bit taller than me. I couldn't really see much of him, and I'm almost positive he was wearing a full black outfit. And he had this mask that he was just over his forehead and his mouth. So, right there, day one, she's been saying the same story. Nothing has changed, right? At 21:2-7, DM gave the description a third time, repeating a mask, and was an inch taller than her, and was basketball player, kind of skinny, and a voice she did not recognize. DM also told Detective Nunez she was kind of in and out of it because she was scared, and it was really, I was really tired. She did not mention anything during the interview about the intruder's eyebrows. Approximately 1:47 p.m. the same day, DM was interviewed by Moscow Police Department Detective Lawrence Mari. During this interview, DM reportedly said she saw a white male she did not know, maybe my height, a few inches taller, skinny, athletic build, wearing all black, wearing a mask that covers just his forehead and here. And I'm assuming she's probably doing this with her hand. Regarding the height, she reported I'm 5'10", so he's probably about 6 foot, which is exactly the height that Bryan Kohberger has on his driver's license. At 15:20, she responds no when asked if she saw what color his eyebrows were, and added, I don't remember what his eyes look like either, but she saw his eyes, and he was definitely a white guy. She again mentioned she was in and out of it because she was tired and explained everything was kind of blurry, like I fully don't remember it. 4 days later, DM was interviewed by Idaho State Police Detective Victoria Gooch, and MPD Captain Dustin Blaker. DM gave a detailed recount of what she did on Saturday, November 12th, until she went to bed at approximately 3:20 on Sunday, November 13th. She stated that sometime between 4 and 4:20, she was woke up and heard a male's voice that she did not recognize, saying, "It's okay, I'm going to help you." She said at this time she was out of it and probably still tipsy, and I believe was still very drunk. Opened the door and saw somebody. Explaining, and I don't, and this is her testimony, so it's going to sound kind of weird because she's all over the place, but it goes, and I don't know how I knew I was someone, because from my mind, it's like I was almost wearing these like blurred glasses, like it's fuzzy and cloudy, but it was like a figure of someone wearing all black, and it was like they had a ski mask that was covering their forehead and their chin and mouth, but I could see the eye. All I remember was seeing their eyebrows, and I don't remember what their eyes look like, but I remember their eyebrows. I don't remember the color of the eyebrows were, just remember they were bushy eyebrows. That's all I could think about. DM described the male as skinny tone, basketball player type. DM stated she was 5'10", so around 5'10", then 6 foot, somewhere around there. DM stated the male was approximately 3 feet from where she was standing, but added that could be out because obviously probably still a little drunk. She had just woke up. I don't remember fully. Is she irritated? I know he looked at me because I could see his eyebrows. I think I just saw one eyebrow. I don't know why or how. For somebody that doesn't know exactly what she saw and was kind of blurry, she sure is giving a very consistent account of what she's seeing. DM then recounted calling and texting her roommates. Bethany, there was someone in the house wearing black and ski mask. DM conveyed to the interviews that she didn't know for sure if it had fully happened. I don't know if my mind's kind of like making up stuff. It's just doesn't make sense to me, and I don't know how to fully explain it, I guess. I mean, most people wouldn't be thinking that poor people are getting their lives taken in your house, right? I mean, that's probably the last thing you're thinking of, especially if you're not hearing blood-curdling screams or people fighting back and things of that nature. Detective Gooch explained to DM that the most important thing was to tell only the things that she knew were true, and DM agreed. She also agreed that she was traumatized and it could affect her memory. Detective Gooch asked DM if she suffered from anxiety. DM responded she did, and added that she had a lot of lucid dreams of being kidnapped and chased. She also indicated that she would watch Criminal Minds and fall asleep to crime podcasts. Detective Gooch and Captain Blaker then sought to reconfirm the facts of DM's memory. DM reiterated that she saw a male figure in the hallway approximately 3 feet from her. He was holding something. He was wearing all black clothes. His forehead was covered. He was wearing a mask. She remembered his eyebrows. Captain Blaker asked what was covering his face, and DM stated, I don't know, weird looking ski mask. It wasn't like the regular ski mask with like eyes, and because I saw his eyebrow, and I think I saw his nose, like the part of his face, but I don't know. She stated she could not see the male's mouth, did not remember if she saw his nose, but confirmed, I know I saw his eyebrows. And I don't remember his eyes. I just feel like I can see eyebrows, but I mean, that could be it. I mean, that would make sense why the forehead was covered up and part of his face was covered. The investigators inquired if DM could provide a composite for the artist, but she said she could not. Again, reiterated she did not remember what his eyes looked like. I don't remember what his nose looked like. I just remember eyebrows. Don't know exactly what the eyebrows look like, really. Just remember thinking like eyebrows. Yeah, bushy, but that's all. Like, I don't remember the shape. I don't remember like the color. I just don't remember. I just remember like bushy eyebrows. That's the only thing I can remember. November 13th and 19th, law enforcement took photos of DM's bedroom. On the walls there was magazines and photos, drawn pictures pinned on cork boards. The drawings were of humans' faces and emphasis. Hold on, I moved. Oh, there it is. On eyebrows, some of the eyebrows are heavy. On December 1st, 18 days after the first interview, DM was interviewed by forensic interviewer Eric William. DM detailed the account on Saturday, November 12th, until she went to bed. DM reported heard a man's voice. It wasn't Ethan's. It was like it's okay, I'm going to help you. DM said she saw an all-black figure about my height, a few inches taller, wearing a mask. DM again said she saw, like, I don't remember, it was just one eyebrow or two, but it was just like this bushy eyebrow. She described texting BF about the guy in all black. I mean, everything is just very consistent. I mean, I don't want to read everything over and over again, but everything is super consistent with what she's saying. At one point, she says that the mask was squared, which is like the balaclava mask. I mean, this is all before she was asked to draw and asked to see what one was. At the end of the day, the order is that they're based on foregoing the defendant's motion to limit the witness identification, bushy eyebrows is denied. So they're going to allow her to have her motions. You know, again, very consistent. Everything that she said. I mean, I read it over and over again. I felt like I was reading the same thing over and over again. Very consistent in what she was saying. So take that for what it is. I got one more document to go through, and then I'll be taking your guys' questions. I know we've got a fee start, and then we'll be calling it a show after that. So this one is the order in the state's motion to eliminate the neuropsychological and psychiatric evidence. The state seeks to prohibit defendant from offering any testimony during the penalty phase in connection to his neuropsychological and psychiatric evaluations performed by the experts, disclosed experts Rachel Orr or Dr. Elaine Ryan. The state argues the proposed testimony falls outside of the mental condition evidence. Defendant responds that he is not relying on the proposed testimony as a mental element defense, noting that his relevant diagnosis and physical conditions, not his mental conditions, rather he intends to present the evidence to aid the jury in understanding both physical implications of his diagnosis and contextualizing his allegedly unconventional courtroom demeanor. Let's see. Facts. During the course of this case, the defendant team retained Dr. Rachel Orr, a clinical neuropsychologist, to conduct a comprehensive neuropsychological evaluation of the defendant and issue a report. She ultimately diagnosed the defendant with autism spectrum disorder level 1 without accompanying intellectual or language impairment, ASD, and obsessive compulsive disorder, OCD, among others. She also listed various diagnoses for which the defendant met criteria in the past, not currently, but in the past. One of those was development coordination disorder. While the defendant is diagnosed with the least severe form of ASD and all accounts is highly functioning, both Dr. Orr and Dr. Ryan noted deficiencies in his behavior to include intense eye contact. See, I don't know. I don't know. I'm not a psychiatrist. I'm probably not going to put too much word into it, but you know, I always thought one of the autistic symptoms was the lack of eye contact. This guy has intense eye contact. Restricted range of affected, occasional subtle rocking of his upper torso while seated, awkward gestures and interaction, atypical tone, lack of appreciation for personal space. I mean, it's his lawyers that are all over him. It's not the other way around. A penanic speech, whatever that means. However, Dr. Orr also observed that the defendant demonstrated typical social behaviors such as fairly consistent eye contact, polite demeanor, and social conventions, shaking hands upon greeting. She noted, and so this is the other thing. I mean, this is why, like, defense experts, I feel like they'll do anything for a buck sometimes. Not all of them, but I mean, she's coming up with all these things and she's talking about, all right, well, these aren't very consistent. You know, he's got the eye contact, he's polite, he's got social conventions like shaking hands. Okay. She noted the defendant engaged in conversation and was never overly inappropriate. Dr. O noted that the defendant manages sensory processing differences by self-soothing activities like driving and extensive time in the dark. See, this is one of the things I'm saying. They're trying to use those things of driving, like they're going to, you know, washing the hands, all that stuff as part of his autism so you can't use it against them. This is all ploy. It's all ploy. Defendant's OCD is manifested through compulsive cleaning behaviors and taking precautions to avoid contamination, sickness, or germs, or a crime scene. He excessively washes his hands and reported use gloves during basic everyday tasks. Although the defendant does not carry a current diagnosis of DCD, Dr. Orr opines that he met the criteria for the diagnosis in the past. And she explains in a report, while motor problems have not impacted his functioning significantly in many years, continues to present with impairment with fine motor dexterity and vulnerabilities in visual motor functions, evidence in his cognitive profile and observation of behaviors. But like I said, washing his hands, wearing the gloves, all that stuff to try to not leave his DNA behind or to evade an investigation, they're going to try to say, oh, you can't use that. You can't say that about him because he's autistic and that's part of his autism. And it's not part of him being, paranoid because he committed a quadruple homicide. The only observation Orr made with regard to the defendant's fine motor dexterity was the defendant moved his arm and repositioned his upper body slightly to manipulate the items effectively. Okay. That's the only thing. And that told her in the past that he had some problems. Idaho code applies to any issues of mental condition in any legal proceedings at which the defendant's mental health condition may be an issue. Mental condition should not be a defense to any charged criminal conduct. Nothing herein is intended to prevent admission of expert evidence to the issue of the state of mind in which the element of the offense subject to the rules of evidence. The defendant is not intending to use the diagnosis to challenge the state of mind elements of the crimes in which he is charged. In fact, he is not intending to use his diagnosis as a reflection of his mental state at all and disputes that they are mental conditions in the first place. Thus, because the defendant is seeking to introduce his diagnosis to explain physical deficits rather than mental deficits that disqualify him from forming the intent necessary to commit the crimes, does not govern the analysis. All righty, let's see. With regard to the evidence of his ASD, the defendant contends that the relevance to explain that his ASD diagnosis is a physical condition and how it presents in his demeanor. Specifically, the defendant asserts testimony about his ASD will help the jury understand that his behavioral characteristics, such as his flat affect, intense eye contact, awkward body posture, and or lack of emotive responses are associated with the ASD and should not be interpreted as sinister light. Defendant argues that he should be able to introduce this evidence at the outset of trial. The state responds that defendant's demeanor is not a fact of consequence in this case, and it's not even evidence and the jury can consider, at least if he does not testify. That's true. While the relevance of the defendant's demeanor is raised, different context here, the principles of this body of law apply equally. The Supreme Court has declared that one accused of a crime is entitled to have his guilt or innocence determined solely on the basis of evidence introduced at trial, not on grounds, not on adduced as proof of trial. Moreover, the court has had the opportunity to observe the defendant through multiple hearings over the past several months, some lasting all day. Not once has the court perceived the defendant to being acting in odd or incongruent manner or otherwise demonstrating signs of counsel to table that would warrant any explanation to the jury. His demeanor has been entirely appropriate. The state has indicated it will not present any evidence from the witness about the defendant's alleged odd behavior. Consequently, testimony about the defendant's ASD is simply not relevant if he does not testify. Moreover, introducing such evidence risks confusing the issues, misleading the jurors, and wasting time and potentially unfair prejudicing both the defense and the state. So basically what they're saying there is if they go into it and they say, hey, Bryan Kohberger is going to, it's kind of like, have you ever seen that movie where they're like, hey, don't mention anything about the guy's mole, and the guy's like, what mole? And then you go and there's this big old mole, and now the guys are looking at it. I think like Austin Powers is one of the movies I think that does something like that. It's kind of like this, right? They're gonna say, hey, Bryan Kohberger, he looks really straight and he has an intense look and he doesn't move, he lacks emotion, and sometimes he'll rock, but very cold. These things may not even be something that they notice, but now they are going to notice. If the defendant testifies evidence, so basically at the end of this, the order is that they're granting the order for the state on the order of the state's motion eliminated the neurological and psychiatric evidence, and they're not going to allow Bryan Kohberger to go up there or his defense team to say, hey, he has autism and be careful with his behavior. Now, if he testifies, that's a different story. But at this point, it doesn't appear that he is. And so they're not going to allow that. And which I don't think they should. I think it's just all waste of time, to be honest with you. All righty. Let's see. Let's go through some of these comments. I'm going to go through the super chats first. We have Allison Rose, a new member. Thank you, Allison. We got Midwest coming in, also becoming a new member. We also have a Las Vegas Girl 122, been a member for 13 months. Thank you, guys. We appreciate you. Lisa H 499, thank you for your updates and guests sticking to 100% the facts. Thank you. And we're going to have another guest coming up here pretty soon. I have a lockdown Steve Goncalves, father of Kaylee Goncalves, for an interview. It hasn't happened yet. It's supposed to happen here pretty soon. I've locked it down in the next few days, in the next couple of days, actually. It's going to take a couple of days to get it out just because we're going to record it. We're going to send it off to make sure that we didn't violate any gag order before we release it to the public. So just FYI. So make sure you like, comment, subscribe, the whole 9 yards. But yes, thank you so much, Elisa H, for your comment. All right. We have Justine coming in with a gifted $1 Drunk Turkey Show membership. And then she comes in with a $2 super chat. Thank you so much. We appreciate you. All right. So let's go through here. So James comes in, sociopath, psychopath. No need to say the obvious. That's true. That's true, James. Let's see. Ken Opener 68. He tried to delete his Amazon history. He did. He tried to delete his Amazon history after he purchased the knife. He tried to. That tells you some stuff, right? Like that's when he decided he was going to commit a murder. He was trying to hide his tracks. It's one thing to purchase something, right? And another thing to try to disclose what you're purchasing. He could have purchased that knife for numerous of things. If it wasn't for an illegal purpose or a legal reason, there'd be no reason to hide it, right? Let's see. Not to concern themselves with the nature of the tip. Why? It is just right. They don't want the tip to come out either. They don't want it to be that the IgG. But I would rather it be an IgG. If I was Bryan Kohberger, if I was on the defense team, if I was his lawyer, I'd say, hey, look, man, they already know it's your DNA on there, right? We're going to argue that it was there by indirect transfer. So even if they were to have tested it and it came back as yours, we're still going to argue. They already tested it. We already know it's yours. We're going to argue that it was there through indirect transfer. So what does the IgG have to do with anything, right? But you throw that out, now it's just, there's a tip. Now it makes you wonder, makes you think, makes you go, who's the narc? Who told on him? Who did he tell? You get what I'm saying? So I don't think it's going to work in his favor. Captain comes in saying, they don't need jurors who've never heard of it. They need jurors who haven't framed an opinion. That's true too, 100%. Rhonda says, I anticipate the length of this trial will be more of a challenge than jury knowledge. Maybe. I mean, there's a lot of evidence against him. Daniel, the courtrooms look small. Do you think they will change it to I'm assuming you mean a bigger court? I don't know. I'm assuming that they're probably going to have it in the same place that they did the Lori Vallow case. That one was a pretty big one, right? That was in the same county. I wouldn't be surprised if the current courtrooms are small because these are pretrial hearings. Now, once the actual hearings come into place, it may not be the same. Let's see. If he has dyspraxia, how can he run a 6-minute mile? No idea. No idea. In Idaho, they need a direct connection between the third party and the crime to argue third party culprit. True story. Most places they do. In most places they do. And I don't think they're going to find one. BK's attorney has a job to do. She's super annoying, but she should be doing her job. I agree, but there's also going above and beyond, like that whole innocent bull crap, right? Saying that, oh, he's an innocent man. And now she says he's an innocent man right now. Or the timing advance records. They found out. He found out. Everybody found out that there was only a 7-day retention period. And after that, she still put forth Cyray's affidavit saying that they believe that law enforcement had him. So those type of things tell me that she's doing more than just her job. My heart breaks for the kids who have been falsely accused. They definitely have dealt with enough without being blamed and harassed. They were friends and they loved the four. I agree. And she's referring to Dylan and Bethany, who have been falsely accused of a bunch of things. And I mean, there's Showalter, there's Adam, there's Jack DeCore, all these guys who have been falsely accused, who still continually get falsely accused, even though the evidence is so strong. Like I said, I mean, if you can't connect these dots, I'm really going to make this shirt. If you can't connect these dots, you shouldn't be looking at dots. You shouldn't be looking at a lot of things. You shouldn't be driving, probably. Do you think they checked back to see if he bought hunting knives before? I don't know. I mean, the warrant was super specific for a specific time frame, a 10-day time frame between March 20th and March 30th, 2022. So maybe, but I think and they also intend on bringing one of Bryan Kohberger's family members to testify. So wouldn't be surprised if they find something there. Let's see. Did you hear people at the hearing said Kohberger is still a deer when cameras roll, but laughs and chats with his attorneys when the court is adjourned? He still is a deer when the cameras roll, but laughs and chats with his attorneys when the court is adjourned. I mean, that's what that one kid said, right? That he was he attended school with at DeSales, that they were doing a project and he was laughing and then he could turn it off real quick. So he definitely probably been masking who he is for a long time. Danny Rolling, I believe, beheaded people with his knife. Am I confusing him with someone else? I'm not familiar with Danny Rolling. Why are they calling it the dollhouse? To me, that's creepy. The reason they call it the dollhouse, that's the defense's being disrespectful about the exhibit from the estate. It is a representation, a model of the home, but the defense, being immature as they are, call it a dollhouse. It's court. It's a giant argument. Why are they banning speech, especially words that fit or stick? Has he submitted to a psych evaluation from the state? No, I think they actually opposed it. I think the state wanted to bring somebody neutral in, and Bryan Kohberger, his defense team, don't want to do it. Have you ever looked into the attorney who is going to prosecute Bryan Kohberger? Which one? The new one? The one that they just brought on? The new attorney? Oh God, what was his name? I can picture him. I can't remember his name off the top of my head. I did look into him. The guy, apparently, from what I understand, and I've talked to some people close to this, he's an impressive lawyer. So Bryan Kohberger has a lot on his plate right now. Having touch and contact DNA banned will work against BK. With the jury, since it now becomes his DNA on the knife sheath, not his touch DNA on the knife sheath. Stupid. I couldn't say it better myself, Mark. Oh my God. That's exactly what I was thinking. I was like, this is stupid of them to do this. Love it, man. Let's see. If it was true about the fight and Ethan, someone would have spilled the beans already. There was no way that these young people could have been quiet for this long. I agree. That's also like the Papa Rogers thing is weird too, because don't you think that whoever that person was would have, somebody would have came forward? Oh, I know who that person is. That person was such and such, whatever the case may be. Food for thought, right? I want everyone to know that I was friendly to this great chat and the friendliness. Thank you, Regina. And yes, Afton is amazing. She is. She's a supporter, not just here, but also on my State of the Steelers. She watches my the Drunk Turkey Gaming channel. If you guys haven't seen that one, just look up Drunk Turkey Gaming. You'll see me. I'm actually going to do some lives here in the near future where I'll be playing a couple of different games. If you guys are into games, check it out. I do some sim racing, and that's the one I'm primarily going to do, and also some Fortnite with Hyman and the boys. Let's see. Did the judge allow the pic of the morning after photo? Yeah, because everything in the bushy eyebrow thing was granted. They're allowing it. I don't think I don't think they specifically said that they were going to take it out, but when it came to the bushy eyebrow stuff, that was specifically one of the things that was highlighted, and they're allowing it all. Now, people are absolute horrible about DM and BF. It sucks that people can't be so cruel to these young girls that went through something like that. Oh, I agree. I'm still curious what is missing from the chem lab. So I talked to Howard Bloom. Howard Bloom says that nothing's come out of that. He says that there's something there, but nothing's coming out of it. So I would. So when I looked at what's in the chem lab, it's more than chemicals. There's everything: office supplies, radios, police radios. I suspect it's something like that. I don't know if we're going to find out if something actually comes out of it. But that's what Howard Bloom said here recently on an interview we had. Midwest says it's a play that he's autistic, but doesn't he have to take the stand to even be considered? I mean, to be considered autistic, probably not. But in order for the jury to hear that he's autistic, he's going to have to take the stand, because the concern is his weird behavior, and apparently he acts odd. Daniel, what if at last minute he enters a guilty plea because he knows he's done either way? Will we see the evidence? Ooh, I think so. I think there's the Freedom of Information Acts that are going to go through, and people are going to see a lot of stuff. The traffic stop that he had, because once this case is closed, that all becomes public record. Everything becomes public record. Once the case is closed, it just needs to be closed. And do I play Call of Duty? I have not played Call of Duty in a long time, Patrick. I might be getting into it. I got to talk to the homies. They're the ones. I play games because I play my first person shooter games because of them. It's just a way to hang out with my buddies that I've known for so long. My sim racing game, I have a whole setup. I have a wheel, clutch, pedals, shift knob, shifters, whole 9 yards. I actually took a seat out of a Honda Del Sol and put it on my sim rig, and it's a pretty legit little setup. It's no Joe Rogan setup, but it's a nice little setup. And I just hit a 6-minute something in the Nürburgring in my my GTR that I have. So super proud of that. I'm fairly new to it. But I did do a lot of driving back in the day. I've taken a lot of driving courses when it comes to driving fast. I've had a lot of fast cars. I've had a LC 500. I had a GT 350. I've had an SRT Challenger, 6 Series BMW, Supra, a couple like 3 or 4 Camaros, WS6 Trans Am. Ooh, RSX Type S that I supercharged. That was my sleeper at it. It was a K20 with a Jackson Racing supercharger with a pulley, Honda ECU, 1400 RC injectors, whole 9 yards. I mean, I think that one I was pushing like 9 pounds of boost on that one on my supercharger, and I was running probably about 11s. It was my sleeper in the quarter mile. Right now I have a little Honda Civic hatchback. I'm actually going to be doing some videos on it, and I'm in the process of potentially purchasing. I haven't decided yet. I kind of decided, but I'm getting kind of cold feet. I'll be honest with you guys. There's a VR4, 3000 GT VR4 that's for sale in my town, and I'm interested in buying it. I got the guy to come down to an acceptable price for myself. I just got to pull the trigger on Monday. I just got to go to the bank and pull it out and then go pick up the car. So twin turbo, all-wheel steering, all-wheel drive. It's super nice. It's super nice. It's been restored, and so I'm paying a pretty penny for it. But my goal is to hold on to it for a little bit, and then maybe get a vet here in the next 3 years or so. I'm done paying my truck payment. I got a Ford, and my truck payment's done in the next 2 years, and so my thoughts are, if I do buy these cars, I might sell them. They're rare cars, so the value should go up pretty good. And I think I should have a pretty penny for that Corvette I want. So, but we'll see. I think I might actually do some content on it, with the channel. So if you guys are interested in automobiles and gaming and stuff, check out Drunk Turkey Gaming. The automobile stuff, I'm going to do it on this channel. I'm not going to create a new one. It's just going to be on the Drunk Turkey Show. But stay tuned for that. Like and subscribe. But that's all I got for you guys today. It seems like that's everybody and everybody's comments and questions. I appreciate everybody for coming in. I'll be back on Tuesday. Not sure what I'm going to talk about yet, but I'll be back Tuesday night. By then, my interview with Steve will have been completed. Maybe I'll talk a little bit about what we discussed, if there's anything that I can talk about, but I'm not going to actually show the interview or anything until after I get the okay for it. But we'll see you guys on Tuesday, guys. I appreciate everybody. Have a happy Thanksgiving, and be safe. Until next time.